All right. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justice of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth, draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. Welcome to an August 3rd, 2021 sitting of the Single Justice of the Appeals Court. My name is Vicki Henry, and I will be the only judge with us today. We are hearing matter 2021-J-0239 WM Oak Grove Village LLC v. Scott. And we're going to hear from Mr. Scott first.
Good morning, Your Honor, and Mr. Papadopoulos. I want to address first the legal sufficiency of the notice to quit. As you know from the papers, there was misrepresentations made in the notice to quit, and at least in the August 12th notice to quit, relating to the belief that the landlord felt unsafe because federal agents had supposedly wanting to break into my apartment to arrest me. And a second material misrepresentation was with respect to Mr. Buscemi, that he had a violent criminal record. The legal adequacy of the notice to quit is an element of the plaintiff's case under Cambridge Street Realty versus Stewart. It's not subject matter jurisdiction, and I don't have any issue with that. I did not waive the argument in the lower court. And it's also recognized that the definition must be, or the defective notice would be a material error or omission. And by implication of that, an intentionally false statement of inclusion would also be defective. That's under the authority of Cambridge Street Realty versus Stewart, which I've cited in the papers. I would also point out that in Baptisti versus Kennelly, I'll spell this as B-A-P-T-I-S-T-E versus Kennelly, K-E-N-N-E-A-L-Y, which is a federal district court decision by Judge Wolf, cited at 2020 U.S. District Lexus 176264. In footnote 9, Judge Wolf recognized that a unauthorized occupant lease violation would be a non-essential lease violation. This is in dicta. With respect to the failure of the Norfolk jail to produce me for the previous hearings in the lower court, the denial of the habeas to the U.S. Marshals, the magistrate judge, and the district court judge the suggestion that Attorney Jacobs, who represented the lower court, would be able to provide copies of it himself to the court, to the jail and the marshals, et cetera, et cetera. It's just simply, ridiculous suggestion. The jails would not have accepted them from him. Neither would the magistrate judge or the district court judge. So the simple fact that
Mr. Scott, who had the duty to properly prepare the habeas papers below?
The duty would be, the motion was made there were two motions made, one for issuance of a habeas. That would be Attorney Jacobs, at which he did do so. And they also requested, once they found out there was an issue with the marshals needing approval to produce me, at that point, he filed a second motion for a habeas for notice, asking that the marshals be served along with the district court judge and the magistrate judge. And that was incumbent upon the lower court, upon counsel to do so, and he did so.
So I understand that you have the arguments that you are going to make on appeal, and assuming that I conclude there is that they're not frivolous. Part of the issue that we're supposed to discuss today is what would be the fair market value of the apartment, and and how much I should balance that against other considerations. So I have some questions along those lines. So first is, are you only challenging the bond amount, or are you also challenging the monthly use and occupancy?
I'm challenging both.
Okay.
That's why I was addressing the issues with respect to the lack of frivolity to the appeal first.
Okay.
And I believe actually I've concluded with that portion of the argument.
Okay.
With respect to the use and occupancy, the fair market value, I contest that. The comparables that were submitted to the court are not exactly comparable in several respects. One being they were both buildings that are built in 2019 and in 2020. The subject premises is nearly 20 years old, if not in excess of 20 years old. The size of the apartment is not comparable. So 1,000 square feet versus 1,145 in one, 1,239 in another, and 1,300 in the third. The 1,300 property was in Medford. The other two were the Malden properties that were submitted.
So let me pause you here. How long had you been a tenant at the complex at the time of your arrest?
Since 2016.
So for about 4 years?
4 years, correct.
Okay, and you had a 2-bedroom?
2-bedroom, 2-bathroom apartment.
Okay, and you were the sole occupant listed on the lease, right?
On the lease, that's correct.
Okay. And my understanding is that you have, am I correct? You have pleaded guilty to some federal charges?
I have recently, yes.
Okay. The lease was, am I correct? The lease was set to expire on its own terms on March 28, 2021?
That is correct.
To ask the obvious question, you did not renew the lease? You and the landlord did not renew the lease?
That is correct.
And did you give intent that you wanted to renew the lease?
Well, the landlord had already initiated these proceedings.
Okay, all right.
So I did not think it was necessary to give that intent at that point.
Okay, that's fine. I just wanted to make sure I understood one way or the other. So what do you think the fair market value of, well, first of all, when you say it's 2 bedrooms, 2 bathrooms, what was the size of your apartment?
I don't have an exact recollection from the floor plan because I haven't seen that since 2016, or I haven't looked at it since 2016, but my memory is roughly 1,100, roughly 1,000 square feet.
Okay.
And
so you're saying your apartment was smaller than the apartments that the landlord provided as comparables, and so those had higher rents?
Those had higher rents. And there's also another factor with respect to the 2 Malden properties. Those were featuring, in their promotional advertising, were featuring 2 months free rent, which would push down the value per month of a 12-month lease. For example, on the property that was 1,145 square feet in Malden, the rent was $3,060. That was listed as the asking price or the rental price, but that would have worked out to have been $2,550 with 2 months free rent. With the 1,239 square foot property, it would have been the rental price was $3,300, and that would have been roughly $2,754 a month. There's another factor that goes into this element is that Windsor is very heavy in promoting 3 to 6 months leases for the corporate market rentals, which carry a higher rate, a significantly higher rate than a 12-month or greater lease. All of which is just the comparables are not really comparable.
Do you have
And
any idea what the vacancy rate is for the complex in which you lived?
I don't know the vacancy rate, but I know that during the 4 years I was there before I was arrested, there was a very high turnover. I had many neighbors who would be there for 3 months or the 6 months. So it was a significantly high. They'd be moving in and they'd be moving out. There was a moving truck there virtually every weekend.
Because of the corporate rentals?
Because of the corporate, I mean, most people who wanted to stay stayed. but there were a tremendous number of corporate rentals.
So what do you think the fair market value of the apartment is now or in April?
I would say somewhere between 2,000 and 2,500. Given the overall state of the economy, although the economy is coming back, you still have hundreds of thousands of students who have not come back yet. And that just pushes down the whole market. And based on what I read in the newspaper about it, the housing market is booming, but the rental market, not so much so.
What else would you like to tell me?
Okay, with respect to the use and occupancy, periodic payments, I would also suggest that, contrary to what was argued in the papers, that 239 Section 8A is not exclusive as far as, my time has expired.
I'm going to give you a little bit more time, and don't worry, Mr. Papadopoulos, I'll give you time to make your arguments.
Okay. That 239 Section 239 or Chapter 239 Section 8A is not exclusive in precluding offsets being considered, because Chapter 186 Section 14 explicitly provides that offsets can be considered, considering if there's a 93A claim or a breach of quiet enjoyment. The Massachusetts Attorney General regulations have swept in landlord-tenant violations as being a 93A claim. And I properly served 93A demand letters, which the court was provided with copies. And the statutory damages far exceed the value of any use and occupancy that would be forthcoming during the pendency of an appeal.
So
Finally,
my understanding is that you haven't actually yet brought the 93A claim, is that correct?
That is correct. And
Okay.
that's due solely to limitations of my time. I have an hour and a half a week in the law library. And between handling these matters and issues having to do with the federal case, somebody hadn't had sufficient time to draft and type the petition or the complaint, which I expect to do so within the next week or two.
Okay.
And then finally, and under Davis versus Comerford, the court is required to balance the equities as far vis-a-vis an indigent defendant versus a $1 billion landlord. And there's been absolutely no showing by the plaintiff in the housing court or in this court of anything that would be suggestive of the balancing of the equities. They just simply want what they think is the contract rate. And that's my argument.
Is there anything else you want to tell me?
No, Your Honor, although I would like a minute or two, if possible, to respond to whatever Mr. Papadopoulos has to argue.
Okay, we don't usually do rebuttal in the appeals court, but I'll give you 2 minutes at most, okay?
Okay, thank you, Your Honor.
All right, Mr. Papadopoulos.
Good morning, Your Honor. I don't know if I need to wait for my time.
There you go. And as I say, if you need a little, I want to make sure you feel like you were heard today.
All right. Good morning, Your Honor. If it may please the court, my name is Attorney Ted Papadopoulos, and I represent the plaintiff in the underlying case, the appellee in the instant motion. My understanding, Your Honor, is that this is a motion to review the appeal bond waiver. And while I understand that there is some review that the court is required to do, especially on the basis that Judge Mudawar on the lower court indicated that there was no non-frivolous basis for which the appeal was raised. I think it's important to take a look at the decision of Judge Mudawar in coming to that determination. Nothing was done rash. This is a case that was filed in August of 2020. There were several continuances and delays, multiple motions. There was a motion to dismiss the case altogether that was heard by Judge Muirhead and denied. This is a fault-based action where several of the arguments and the counterclaims that were filed were also denied by the court for what Mr. Scott indicated right now at the very tail end. Under 239-8A, there are no defenses or counterclaims. Those are only available in a case of non-payment of rent or in a no-fault action, neither of which is the case here, this is a fault-based notice to quit, a fault-based action. So the lower court has already made a determination that those counterclaims or defenses wouldn't be applicable here. Had there been any discrimination or failure to reasonably accommodate, those types of arguments have been historically reviewed and argued in fault-based actions. But the ones that Mr. Scott is raising under 93A or unfair and deceptive acts or practices, those are simply not applicable in a case such as the one that's before the court.
Mr. Papadopoulos, what do you understand to be the basis for the judgment for the landlord? Do you understand it to be the lease violation by having an additional occupant?
Your Honor, I think it's a combination, and if I may have a quick second, Your Honor, in terms of the determination by Judge Mudawar, the argument that was raised that this was not an essential eviction under 257 of the Acts of 2020 was resolved by the judge, ultimately indicating that this is a case that that we were not required to prove an essential eviction. We're again dealing with that statute or that bill that was passed in April of 2020. Judge Mudawar reviewed, analyzed, and applied it, indicating that this is not a case that would have to fall under an essential eviction. So the decision made.
My understanding was that he basically said, the way I read it, and it was not the clearest, or at least I wasn't completely following, was that he was saying that the notice to quit satisfied the test for essential eviction, but that by the time you actually got to trial, that was not a requirement. And that the lease violation, it seemed like he found, was having this additional person as an occupant in the lease for the apartment. If you can point me to something else, I guess I'd like to understand that.
Yep. So if Your Honor is pointing to the last page of the order, ultimately where it indicates that plaintiff's counsel and witness established that Mr. Scott is the sole authorized occupant, it is also evident that Mr. Scott never received the plaintiff's permission to permit Mr. Buscemi to reside in the unit, and that there is no separate evidence that was provided to establish that Mr. Buscemi had a tenancy granted to him in granting him a right of possession in that unit. So yes, Your Honor, by virtue of that last page and the decision written by Judge Mudawar, it would seem that he's hanging his hat on that basis, but he also indicates that an essential eviction did not need to be established, that there were, and if I may, Your Honor, I believe it is indicated earlier.
But was there any other ground for actually granting possession to the landlord?
Yes, Your Honor. So in page 2, and I understand that in the order, Judge Mudawar indicates that the plaintiff claims that Mr. Scott violated paragraph 2 by engaging in criminal activity. So it is provided in his decision. It also indicates, one second, Your Honor. On page 3 at the very middle of it, it indicates, and it's not just the basis on establishing the essential eviction. It says proper termination, and he also cited a case that I was counsel on for Cambridge Realty versus Melinda Stewart, where it says here the plaintiff's notice claims that Mr. Scott's conduct leading to his arrest and the manner of his arrest on the property impacted staff and other residents. So
right,
he
but
does
that's a claim. I'm not, I mean, what I have before me is that there's an unauthorized occupant of a 2-bedroom apartment leased to a single person. But I see that you have claims about his illegal activity and the impact of the arrest, but I'm not seeing any other basis for the eviction, right?
Your Honor,
if you could point me to some language, I'm not seeing it.
Yep, and again, I would point again to page 3, that center paragraph.
Right,
it says,
but that's an allegation. Your notice claims.
It is an allegation, Your Honor, but it is a determination by the judge as well, where he says that the question at the notice to quit stage is whether the notice is sufficient. And he says, based on my review of the plaintiff's tenancy termination notice, I find it does allege sufficient facts to fall within the permissible eviction proceedings.
Right, but that's not a reason why he ruled in your, it's not a reason why he found that the possession should go to the landlord. All he's saying is you kicked off the action correctly.
That there is sufficient allegations in the notice to quit.
Right, allegations, but then he goes on to find that he did not credit the claims about criminal activity.
Your Honor, and page 4 in the middle, again, you have, there is evidence that Mr. Scott engaged in criminal conduct. He indicates that there's no evidence that such conduct occurred at the premises. That's not a
Right.
requirement either, Your Honor, under the note, under the
I
lease.
recognize that, but that's not a basis, again, that's not a basis for this eviction. I'm just asking if there's a basis for the eviction other than the unauthorized occupant.
And I would say, yes, there is, Your Honor. The arrest that took place on the property, the criminal activity, and while Judge Mudawar says that there's no evidence that it occurred on the premises, the lease does not require that the activity occur on the premises. It's on or near the premises. Now, I would disagree with Judge Mudawar because we did present evidence that that address was in the criminal complaint that was filed against Mr. Scott. That several times in that criminal complaint, in the statement of the officers, they indicated that those addresses were used, which were at the property. There were
I
several
understand
objections.
that, but I'm asking what bases did Judge Mudawar have for agreeing to rule in favor of the landlord? And I'm not seeing from that paragraph or the other paragraphs you cited that those were a basis for his order. The only basis I'm seeing in his order is the unauthorized occupant of in other words, having a second person in a 2-bedroom apartment. So I'm asking what language in this decision, or you could point me to a different decision, but I think this is the operative decision, is a basis for the eviction, not your claim that he didn't rule for you on, but in fact that he found. Because if I'm missing something, I'd like to, I want to hear you, and I want to know about it.
Okay, and Your Honor, yes, based on the way that it is written, I would say that his decision at the end is based on the unauthorized occupant, that he never obtained permission. And again, it would be, yes, I would say, call it ambiguous. The order does say that the court finds for the plaintiff on their claim for possession, does not elaborate on whether it's just the issue of the unauthorized occupant or the criminal activity. So in that respect, yes, Your Honor, I would say that he has not specifically stated that it's on the criminal conduct, but our claim for possession, we were entitled to it, and that's why judgment entered. And our claim for possession was based on that notice to quit, which raised multiple issues.
All right, so what do you contend? You can pick a point in time, but the fair market value of the apartment, either now or in April 2021.
Your Honor, I think this case is somewhat easier in that we have an active contract between the parties that identifies what the monthly rent and the fair
But that was
rent is.
pre-pandemic, and the rental market is different. I mean, I
Your Honor,
recognize that the rental market has recovered substantially from where it had been, and things are very fluid, particularly with the eviction moratorium on the federal level expiring. But I'm just asking, leaving aside the contract rate, what you think the fair market value of the apartment was,
Your Honor,
either in April or now.
Was and is based on the assistance that's been provided by the government, the federal and state government, which is infusing over $430 million in the state of Massachusetts. I would say that the fair market rent is what is in the lease. In fact, Mr. Scott actually misstates that the rental market is not booming, because in fact it is. Vacancy rates are actually at a much lower rate than they were pre-pandemic stage. And in fact, rents are higher than they were pre-pandemic and during the pandemic. We represent a lot of institutional landlords, and I can absolutely state that. I know Mr. Scott stated, but didn't provide any support for his argument that the housing market is booming, but not the rental market. I'm not aware of any literature that actually makes that representation, but my client's vacancy rates throughout Massachusetts is actually extremely low. So we would argue that it is.
What is the vacancy rate in this particular complex?
Your Honor, I don't have the.
Okay, let me back up. He says this is 18 buildings and 500 units. Is that right?
Your Honor, I don't believe I have that information, and I apologize. And I apologize because in preparing for this motion, the size of the development would not be something that we typically consider to be relevant in terms of establishing what the market rent would be for an apartment in
Well,
this.
if you had 100 empty units out of 500, do you think that would be relevant to the fair market value?
I don't, Your Honor, because I don't think that would drop the rent to $1. I don't believe it would drop it to 200 or 500. You have market rents that what would be important, I think, is what an apartment has rented for in that development recently. That would explain what the market rent would be, because there's a number of factors that would go into why there would be 10 vacancies, 20 vacancies, 50 vacancies, et cetera. And what we provided for Judge Mutawar was not just evidence of fair market rent in that area, but also comparable sizes, both larger and smaller. And Mr. Scott was paying his rent religiously up until this case was filed. So in terms of what was agreed upon by the parties, I think that is pretty relevant and important for the court's consideration. His statement that 2,000 or 2,500, again, I have no basis to understand why that would be a rate that he's coming up with. Mr. Scott simply can't rebut whether it's under Davis, Comerford, or otherwise.
He told you because he says that the comparables that you offered were offering 2 months free rent. And so if you spread that out over the course of the year, then that tells you a lower monthly rate.
Your Honor, even at 2 months reduced rent would not bring it down to $2,000 or $2,500. And what was being offered at the time is also not indicative of the market rent for the premises. Reducing and Your Honor, I actually don't think that that's in the record at all, that there were 2 months free rent advertised on the apartments that were submitted. Mr. Scott has made several statements today, but in terms of the record, in terms of what's been submitted, I don't believe that that's supported by his statements at all. Now, in terms of just addressing some of the statements that Mr. Scott did make today, in the sufficiency of the notice to quit is what he started off with. The case that he cited under Stewart, Cambridge Street versus Stewart, that's a case that I was on, Your Honor, and the validity of a notice to quit is actually a determination for the trial court to make. That was the ultimate decision based on the notice to quit that the Supreme Judicial Court came down with, and that there is no jurisdictional argument that the court would, that a tenant would be able to raise, saying that the court now doesn't have the jurisdiction to hear it. So again, his citation of Cambridge Street versus Stewart is inapposite. There were about 5 continuances in this case in order to allow Mr. Scott to be behaved in. At times, his attorney had indicated during those hearings that he was not aware whether Mr. Scott simply chose to not appear or whether he was sick or otherwise, and never provided any information to the court as to the basis for why he did not appear. After several continuances, the case did go forward. And I believe, if Your Honor, if I was being clairvoyant and trying to really understand why Judge Mutawar maybe didn't go into some of the details of the criminal conduct, it might have been because it was, to an extent, compassionate, that determinations made in this case could potentially impact his criminal case. And rather than do that and say that there was sufficient basis to make that determination, he rested more on the unauthorized occupant, which we have never had the opportunity to vet or review Mr. Buscemi's application. In fact, when we did look into it, and I don't know that Mr. Scott would disagree, there is a long rap sheet of criminal convictions, pleading to sufficient facts and charges. Granted, those are some of them are charges and not convictions. But that's the reason why we do, in a large residential development like this, require vetting any applicant that comes in, because we need to have the ability to say whether somebody is or is not going to be a good member of that residential community based on their criminal background. In this case, Mr. Buscemi absolutely would have been rejected and would have been denied. And that's likely the reason why Mr. Scott never submitted his application for housing and yet continued to allow him to stay there. So in terms of whether there has been sufficient basis, whether there's any non-frivolous basis for this appeal, I think Your Honor also identified that the lease expired in March of 2021. There is no basis for Mr. Scott to maintain a right to occupancy in this apartment home. And the rent that was charged under the lease was agreed upon. We provided ample information as to higher rents that were charged. And if the court is conducting a sua sponte determination of what the fair market rent is, we would be able to submit additional documentation that the rents have likely increased beyond what it was during that lease term that Mr. Scott signed at the $3,099 rate. So, and Your Honor, the only other point I have written down here is Mr. Scott made some kind of suggestion that there's a denial on some of the applications or writs for habeas corpus. That was never the case. In fact, every application for habeas corpus was allowed by the court. And I apologize, Your Honor. My final point is under Davis versus Comerford. I don't believe even the SJC has indicated that under balancing equities argument that the rent would be reduced to zero based on indigency or inability to pay. Again, there's over, I believe, $30,000 in outstanding rent that's due. And at this point, we're simply trying to cut the losses and proceed here, especially where my understanding from Mr. Scott's counsel is that this entire ordeal has been an attempt to maintain housing for purposes of his criminal case that's pending. I have nothing further, Your Honor, and I apologize for going over my time.
Thank you. Mr. Scott, I'll give you just 2 minutes.
Okay, I'll address this very briefly. I'll go in reverse order. The comparables, the comments on the Malden properties that were submitted on June 15th to this court and to the housing court, according to the docket entries. And in the remark section on the two housing court, on the two documents in Exhibit A, the Malden properties in the remark section specifically state 2 months free rent on select apartments. So that's part of the record in the case. And as far as Mr. Buscemi, and had we had the opportunity at the January 26th hearing to present the case, the defense case, I believe the record reflects that the arguments were made by Mr. Papadopoulos for the landlord. They were, Mr. Jacobs then argued a motion to dismiss, which the justice took under advisement, and there was never an opportunity to actually present our defense. And the defense would have been that Mr. Buscemi was in fact a de facto tenant. He was known to the staff. He was known to the management. And in addition, as far as his criminal record, he has 1 misdemeanor conviction that's very dated. It's like 2011, 2012. That wouldn't have even come up in a background check. The background check companies are bound by the Fair Credit Reporting Act, just as the credit bureau, and they would be precluded from reporting any derogatory information older than 7 years. And the only factor that's 1 conviction. It doesn't make any difference how many arrests he had. It's 1 conviction he had, and that was for a misdemeanor. The final factor is actually 2 final factors. The 239 Section 8A argument was never addressed by the housing court at any of the proceedings, and the Justice Muirhead did not deny the motion to dismiss, as argued by Mr. Papadopoulos. She reserved decision until the trial, and then she was not the trial judge. Thank you, Your Honor.
Thank you. I think I understand everyone's positions, and the matter is submitted.
Thank you.
All right, we are now live once again.
My apologies, Your Honor. The only thing I would sincerely and respectfully ask the court to review is the facts and whether the court is willing to take judicial notice or not. Mr. Scott was not present at the hearings and yet has made statements about what Judge Muirhead made in terms of her decision. The record speaks for itself. In terms of the statements about Mr. Buscemi, I have about 30 pages worth of criminal record. So Mr. Scott makes statements unsupported by any record, and I believe is very carefully and craftfully done by Mr. Scott. Unfortunately, the record simply does not support any of the allegations that he's making or any of the pronouncements that he's making regarding either Mr. Buscemi or himself. Your Honor, I would just ask that the court keep it to the record. Mr. Scott had the opportunity to present documents in the record, chose not to, and I think that was done intentionally.
I understand, and Mr. Scott is the only party here. So that is seeking review of this appeal bond and statement of use and occupancy. So I do understand everyone's positions. The matter is submitted.
Thank you, Your Honor.